Okay, good morning, folks. Welcome back. We are now going to be shifting our focus to H30, which is an act relating to the use of seclusion and restraint on children and youth in the custody of the Department for Children and Families. And we have with us folks from the Office of Child, Youth, and Family Advocate. And then in a little bit, we'll be hearing from the Department for Children and Families, Tyler Allen. So welcome back to committee. Appreciate having you here. It's been a little while since we last saw you. So the floor is yours. And I think do we have information from you on our website?
Yeah.
Okay, so you can refer to that. So welcome to both of you. Thank you for being here.
Thank you. Matthew Bernstein, Child, Youth, and Family Advocate for the state of Vermont.
Everyone, Lauren Richby, the advocate with OCYFA.
And we'll each talk more in our roles, but I wanted to say at the outset that I think on this issue, Lauren and I each bring our own perspectives, which are each valuable. In particular, Lauren's having worked directly for DCF as part of RLSI, which she can say more about. Because I think there's the policy part, the law part, which is more my expertise, and I have been a practicing attorney in this field. And represented a lot of clients who've been restrained and secluded. But there's also the practical realities of what it looks like day to day. And that tension is going to be really important as we keep talking. So we didn't do a PowerPoint today. We did a handout, and it's the essentials here. It's front and back. And then there's an excerpt from a federal report about that we talked about quite a bit. We continue to talk about called Warehouses of Neglect, which is about residential care across the United States. And the reason why we tried to sort of pack everything into a handout is because, I know we don't have a lot of time today, and this bill is currently in short form. And I think a lot of what we're talking about here is these issues in general. So just to dive right in. So, some of you aren't familiar with our office. I know this committee's changed a little bit, but it is important to emphasize that we are independent and nonpartisan. And both those things are important. We're independent of DCF, of AHS. And our duty is to represent the interests of children, youth, and families, primarily in the juvenile justice and child protection systems. We're also nonpartisan, which means, what it means. And in particular in child welfare, that's important because child welfare nationally is one of the most bipartisan issues that still remains, honestly. There was a lot of legislation passed at the end of the last administration, and there's even in this administration, there's legislation going through. So that's important to emphasize. And really, the party lines thing doesn't really apply to child welfare, and I think we all share the interests that we're talking about today. So our office, I think skip to the third bullet point here, because this is going to be really relevant as we continue. Our founding statute, which you all helped push forward, requires DCF to notify our office of, number one, all incidents of actual physical injury to children or youths in the custody of the commissioner or at significant risk of such harm, and two, instances of restraint or seclusion of any child or youth in the custody of the commissioner. I included one in there because it kind of gives context to two, which is to say, one of the main missions of our office, and that car horn is very distracting, sorry. Is to be sure that we all know, all of us, policymakers, taxpayers, citizens, parents, everybody in the whole community, including DCF, knows whether our children are safe and has a stake in their care. Let me just take a drink of water. Did you want to add anything while I do that? Excuse me.
And that's inclusive of wherever they are receiving care, correct?
Exactly. I think that's an important distinction, Chair Wood. Even though H30 is focused primarily on residential programs, DCF is still required to report all instances of restraints of children in DCF custody. So that could be in educational settings, that could be in a hospital setting, for example.
Foster care setting.
Mm-hmm.
Right. And later there's a bullet point that mentions that. So yeah, the frame is all children in care, but they can be in many settings. So I'm moving now to the summary of restraint and seclusion part here. I don't know what's in my throat, but I may have to take another drink of water. It is really important in the bolded section to understand that neither restraint nor seclusion are therapy. They have no therapeutic basis. There is not a research base for these things. They are emergency interventions. And I will just say on a personal note, I'm speaking only for myself now. I am not up here saying that we should have absolutely zero restraints, period, end of story. I had restrained my own son before, and I may have to do it again. I have a child with a disability, and he's wonderful, and sometimes things go wrong, right? So we're not up here to, blame DCF for anything, and there's a bullet point on the next page about that. Or to say this is easy and there should be zero restraints. But it is, the data piece is incredibly important because right now we have no idea the frequency, the severity, the injuries to children that is occurring due to restraint and seclusion essentially at all. We basically have no data. And that is even after the statute was passed that requires DCF to report this data to us. And we'll talk more about why that is. Again, we're not here to bash DCF and say it's 100% their fault. For sure.
How many years has that been? Can you refresh my memory? When did we pass the statute?
Yeah.
It has been 2 years.
2 years?
In effect.
Feels like you guys have been here longer than that.
I'm not sure if that's a compliment.
It is. Yeah, of course it is.
There's a bullet point, Chairwood, down under the last sentence of the need for age 30. The last sentence of the first bullet point under the need for age 30. It says, current law is inadequate in the entire existence of the OCYFA. DCF has reported the restraint of just 58 children and the seclusion of 0 children. So there have been many more restraints than that, but 58 individual children. And do you want to say real quick about what the quality of this data that we've gotten? Thanks.
I think another important point in terms of data sets, we just received our first data set of restraint and seclusion of children and youth in DCF custody yesterday. And so that is the first set received in 2025. So we have not analyzed that in the way that we would like to, because it's been almost 5 months of no data sharing. It's presented to us in a spreadsheet.
Give me just a moment. What is it?
I'm just queuing that up. I apologize.
I just didn't know.
I know it's Lester Holt, sorry.
Breaking news that the world has
I'm sorry, it just does.
Breaking news, do we have to?
No, something,
I'm sorry, I just didn't want to fuss with it in the middle of.
I didn't know something weird was happening.
Yeah,
Okay.
let's take it over. That's happened before.
Yeah.
And so the information DCF provides is in an Excel spreadsheet. And each instance of restraint or seclusion is per line. One example I'll give is of a restraint. The date the restraint was completed, the name of the child, their date of birth, the district they're from, the program they were at, and the restraint description read, adolescent female, fighting with injury, hospitalization, psychiatric, PRT, full floor, that's a type of restraint, and suicide ideation. So clearly, when I'm presented with that information, I have several more questions. Who was injured? Was the child injured? Was staff injured? Was it reported to licensing? Who was actually fighting? Was it resident versus resident? Was it staff versus resident? What does suicide ideation actually look like and sound like? How can that inform the child's de-escalation plan? Did they actually do the progression to a floor restraint, right? Did they start standing, then proceed to sitting, and then go to a full PRT floor restraint?
You say what PRT?
I forget, actually. It's PRT.
It's a prone restraint technique or something like that.
I think that's handle with care,
Okay.
is when they say PRT. That's handle with care is one of the modalities used in residential programs. Other ones are therapeutic crisis intervention or TCI, and then CPI is Crisis Prevention Institute.
Go ahead, Representative.
Yeah, thank you. Just quickly, it sounds like you're looking for access to the report because a lot of that information would be disseminated within the report that's
Yes.
provided. Do you folks have access to the reports through the data?
Yes and no. I think that's a great question, and that's some of what we're talking about. And and I will say Tyler has been working with us on this, so we really appreciate that, and he's been really helpful. We have been clear with DCF that what we don't want is them to take the actual reports and boil them down to a spreadsheet like this, because we want the direct reports. So that's one thing. And then the second thing is, in the short form of H30, it mentions like essentially standardization of the reporting. I think that legislatively standardizing what shall be reported might be useful so that it's clear that everybody, that we can compare apples to apples in terms of programs. Did I answer your question?
Yeah, so just a quick follow-up. Is there a templated document that is readily used as that incident report or that?
Every
Right.
So everybody
facility
can-
has its own.
That's not good.
Yes,
I agree.
correct.
I agree. And we're working with Tyler on a lightweight digital system. So instead of like them typing it up into a PDF that then they attach to an email, send to DCF, who then then we decode that into data. If you use something like Microsoft Forms, if you've ever used that,
Mhm.
you fill out an online form and it goes right into a spreadsheet, right? There's obvious practical details to work out with that in terms of privacy and confidentiality and all that.
Yeah.
But that also, if there's standard categories there for everybody,
Yeah.
it streamlines it for everybody, and honestly for the providers too. It makes it easier for them. And also, they have an interest, of course, in knowing what's going on in their own aggregate data. They may keep their own, but us reflecting that back to them, I think if I'm a provider, I want to know about program quality. And, and I'll mention like Depot and See all those programs. They do care about their program quality, and stuff goes wrong there sometimes. And, they're responsive to us when we bring them issues. So
Yeah, so one standardized form is vitally important.
I would agree. Yeah.
Yeah.
No, thank you.
So Representative Donahue.
So, I am deeply familiar with the parallel issues around psychiatric care and treatment. And some of what you just said, actually, to add to what I was already going to ask, is it exists in that system and might be worth looking to how they do it, because they require a certificate of need for any use of restraint or seclusion. That all is centralized, and the mental health ombudsman has a statutory right of access to those reports. They've had some struggles with that, but and it's on their you reference it in your report, but their
Dashboard.
dashboard, thank you. It's on their dashboard reporting on that, including use of restraint in
On whose
transportation,
Right.
Department of Mental Health. This is all
Disability Rights Vermont.
the right. Disability Rights Vermont is the mental health ombudsman under statute. So there's a whole parallel there of an existing system. But that also goes to kind of my underlying question. Are there existing regulations that permit use of restraint and seclusion? Because I looked all over for them last year when we were looking at the psychiatric PTRF program, and the statute added requirements of CONs and all of that. And I didn't see it in residential, because it's like, otherwise it's like kidnapping and stuff.
No.
If it's not.
They're linked in our handout.
They are linked. Okay, all right.
There are several regulations under residential treatment program
Okay.
regulations that are licensed by DCF. And there are separate restraint regulations, seclusion regulations, reporting requirements, and notification requirements, and then also how locked facilities are exempt from some of those regulations, which is significant.
So, yeah, I mean, I think in the interest of, apples and apples on all of these, it would certainly be very interesting to compare. And if the psychiatric regulations on when you can or can't use seclusion and restraint are more stringent than what we have for our children, I would suggest we need to put them on a par, if not stronger. I mean, a child's traumatization
Mhm.
is certainly equivalent to somebody in a psychiatric hospital, and probably higher. So our thresholds at a minimum, because it doesn't sound from some of what you're saying that they're equivalent at all. It
No.
sounds like they are
They're
much more permitted.
They're insufficient. I mean,
Yes.
grossly insufficient to protect children. Unquestionable.
And we've got a model we can look to.
And the observation that you're making, Anne, is not is not dissimilar to things that happen in schools
Yes.
that we prohibit from happening to adults in our community-based service system. But it's happening probably in Vermont every day in schools.
And I appreciate that you mentioned schools as well. At Chairwood, we've been trying to partner with DCF to get all of the Rule 4500 reports to like the DCF family services workers, so the districts have it. And I think there's a little bit of a roadblock there in communication that we still are working through in order to get AOE to report back to DCF all of the incidents that happen in school settings.
Well, honestly, from our work last biennium, I know it's because schools have not routinely reported those
Mhm.
to AOE. I mean, I have no idea whether or not they have stepped up their enforcement actions or not, but that's, yeah, it's an ongoing issue. Yeah. Go ahead, Representative Bishop, and I'm mindful of time, but I want you to have, I want you to know that this won't be the last time we're talking about this. If need be, Lori, maybe you could check with our next witness to see if they might, I know he's on, to see what his timing is about and maybe be able to. Go ahead. No, I'm not going to do that. Yeah. Want to hear both aspects, but we have lots of questions about this. So I want to make sure to be able to take sufficient time and give both you and Tyler sufficient time. So go ahead, Representative Bishop.
Thank you. I just want to make sure I understand the data question. I'm hearing really clearly, and with the example you give, the clarity of the information provided needs to be addressed. But looking at the testimony and the first set, the introductory information, the third bullet point, the two things that DCF is required to do includes notifying of instances of restraint or seclusion. And then in the need for age 30, in the first bullet point, it says no entity knows how often Vermont children are restrained or secluded.
Yes.
Those two things seem in conflict with one
Right.
another. So our
It's not
reports,
working.
reports are not being made.
Well, we've gotten, as we said, we've gotten reports in over 2 years of restraints of 58 children. So the law is functioning to its most minimal amount. But it's not really working. It's not, I mean, like this data is not good data. It doesn't allow us to understand conditions.
So is there reason to believe that the number of 58 children, I know those are unique children incidents.
Correct.
Is there reason to believe that that is an inaccurate
Yes.
number?
Yes.
Yes,
It
so-
should be probably in the thousands, or
I would say hundreds
I would say thousands in 2.5
of
years.
children.
No, of incidents.
Instances.
Incidents.
Okay.
I think what's also how we come to that conclusion as well. We received complaints and referrals about DCF. And in 2024, 13% of those referrals to our office were about concerns of restraint and seclusion that we had not had incident reports for. So we had identified incidents that we hadn't received reports for, and then had to go ask and dig.
There's a known universe of cases.
Yeah.
There appears to be a known universe of cases that were not reported.
Correct.
And so extrapolating from that, there are additional.
Correct, yes.
And I would also say from my experience with residential licensing and special investigations unit at DCF, the reports we're receiving are underreported. The number of restraints and seclusions that I witnessed and watched videos for is much more numerous than what's being reported to us.
In fact, the Brattleboro retreat told us that our number was quite low.
And so is there a definitional difference between what DCF is considering reportable to your office? Or, I'll ask Tyler this when we have him on.
Yeah.
Just for your information too, I put the definitions from the regs in the footnote at the bottom of page 1.
I see.
And there's others, of course, there too, but those are the sort of the base ones. Representative Bishop, just to your question too, on page 27 of our annual report here, there's a little more detail on those reports. So, I mentioned the number of 58 unduplicated children. That was 324 total instances of restraint. Which, one point that makes is, a relatively small number of children are restrained multiple times, right? And there's some more detail here about programs. For example, the CL programs, all of them, including, 204, 206 Depot and the Girls Adolescent program, reported almost 300 instances of restraint. So that's closer to realistic. You see why I say we'd be in the thousands? That's one program out of, 30-ish that kids go to, right? And so that's another sort of, it's a metric to try to measure this. I don't know if those are, those might be low as well.
And you said 30 programs, and I'm just looking on that same page, 4 total programs reporting.
Yeah.
Correct.
So 20,
Another
26 had 0
correct.
restraints.
Correct. And nobody reported any seclusions at all, which again, the retreat told us they.
Unlikely.
Yes. So I did want to share this video. It's not very long. The video is like, I don't know, it's a couple minutes. You can watch it on your own time. I'm just going to share less than a minute of the first part of it. I think that a number of you probably have not seen what a restraint looks like. And this is really just the beginning of this. And I'll say a couple things. This is hard to watch, but it's not as hard to watch as what happens after it, right? I'm going to stop it before it gets really hard to watch. The reason why I'm going to show, and it is edited, right? This is the nightly news. The reason why I want to show it to you, a couple things. One, so this young person you'll see throws food. There's 2 instances, throws food, kind of like this. And then is surrounded by a bunch of very large gentlemen, and then again throws food like that. And if you can, and again, the link is in here so you can watch it on your own time, just notice how aggressive it seems to you, right? And then notice what the adults do after that. And, there isn't any audio either. So this is a selective picture, but I do think that it tells a story of something that's not uncommon, honestly. So hopefully this will work. I did share the sound.
Shocking death of a 16-year-old at a youth facility run by a company we've investigated before for past violations. We want to warn you, some of the video you're about to see is disturbing. Here's Kate Snow.
You're looking at video of 16-year-old Cornelius Frederick having lunch at Lakeside Academy, a home for at-risk youth in Kalamazoo, Michigan. There's no audio, but Cornelius is seen throwing food. 2 staff members intervene, but when Cornelius throws another item, he's pushed down. 2 men become 3, then 6 on top of him. After at least 10 minutes of restraint, Cornelius is lifted up, limp. And then watch what happens. Staff members, including a nurse, stand around for another 12 minutes. Then the nurse.
So I'm just going to stop it there because I think it makes the point. Honestly, so this youth died, and that is unfortunately not as. Let me stop sharing here. Unfortunately, deaths are not as rare as they should be. I think the point for me here is even when a youth doesn't die, this is really not uncommon, right? You can testify to your own experience. But there's the general dynamics of this, right? A youth who is being a pain in the butt, being non-compliant, right? Then the physical intervention is overwhelming, right? And it's part of the culture of programs like this. And I'll just say too, and I had a hard time yesterday after watching just as much. I read about this story in Warehouses of Neglect, and there's some excerpts that I included here. If you say this shouldn't happen to a Vermont youth, in Warehouses of Neglect, in that report that we linked here, they tell this youth story, and the very next story is about a Vermont youth. And it's honestly, aside from the death part, imminently, it's almost worse. And it's I didn't want to read it in here because it's challenging. And that youth did eventually die by suicide later. And so, Vermont youths go to programs like this all the time, right? And we can talk about the need for that. We can talk about the system of care. We can talk about all these things. But it's just important to understand, but these are behind closed doors, right? If we don't know what's happening to these youth, it's much easier for it to continue to happen, right? And we really, there's been a lot of defensiveness. I think the session is wearing on, and in a bunch of different sets of testimony, and I really like, I just think it's clear to everybody that this is a shared problem, and it's not to point fingers, but we really do need to do something about this. So.
Representative Downey has a question.
Well, it's not so much, I just want to, the comparison again, last year, this legislature adopted requirements for adolescent psychiatric residential treatment centers, which required that all of the rules on restraint and seclusion be identical to other psychiatric facilities. The reason for doing that was under the belief that these kids were going to be in a locked facility and therefore needed that higher standard for the kinds of things that did not happen. Belief that it did not happen in our residential, which are not locked facilities. So the idea was, because this is going to be new and different, we need to protect these kids the same way anyone in a locked psychiatric facility is protected. So there was no action in terms of unlocked residential facilities because there wasn't an awareness that that was already happening.
I think that's a challenge, right? I think that also Rep. Donahue gets to our recommendations of what else to consider in 830 about the public dashboard. You can see licensing reports, incident reports, with confidential information removed, and pending lawsuits in other states. They'll have all of their programs listed, and then you can see the status of each in a public facing way. That's really what my time at RLSI taught me, is that the public needs this information, and in Vermont deserves to have this information open and out there and transparent, because this is happening behind closed doors in a pretty small, secretive group.
Well, and I would add that this committee, when we visited the future Red Clover, expressed concern around, well, we hope kids aren't going to be locked in their rooms.
And they have-
Seclusion. But again, operating on the assumption that that might happen because it was a detention facility, as opposed to it happening in residential.
And I think that's another clear recommendation to tackle either in H30 or in larger rule procedures, is that our residential treatment program regulations must be rewritten and definitely remove the exemptions or modify the exemptions for locked facilities, because we have already paid $4.5 million for those exemptions, right? With the Woodside lawsuit. And that will happen again. And to your point, we just received incident reports, the first ones at Red Clover, and without further analysis, it appears that a youth was handcuffed in his room for at least 2 hours.
So that's mechanical restraints, exempt.
And in hospitals.
Yeah.
Right, exempt,
Yeah.
completely exempt in a locked facility, and Red Clover is a locked facility. Chemical restraints are also exempt from the regulation. So Red Clover could use chemical restraints as well, which was an issue with Woodside as well.
Chemical restraints, meaning drugging.
Yes.
Yes.
Yeah. I think another point, if I can just, put it all out there, especially since of this video, one main challenge as well was the lack of audio recordings during video restraint seclusion. That information is crucial in order for the licensing authority to perform their job duties. And so an investment in our residential programs to have that capability, because it is very costly, it is something to consider as well.
To make a couple of points too, because I know we're running short on time. You saw in the video a Black youth who lost his life. And that in aggregate nationwide, we know, and it may not surprise you, that that anybody with a marginalized identity is more likely to be restrained and secluded, including, you know, Black and brown children, children with disabilities, and other marginalized groups. And there is a link to a study that's one example of that. I also wanted to emphasize this, and this is something that I am critical of, and I'm critical of systems, not of individuals here. But I think this is a clear example, excuse me, of systems overwhelming people and people having lost track of that. DCF recently issued its RFP for its new CWIS system, right, which is its Comprehensive Child Welfare Information System, the new federal standard. You have heard many times about the current system. And I guess I'll say, by the way, since I'm on this, I think we are verging on using the current system as an excuse at this point. And I'm a little frustrated with that, since I'm airing my frustrations. But anyway, so let me get to the point. The point is the RFP went out. We recommended they do this in what's called an agile manner, which means essentially you pay somebody in an ongoing manner to develop the system as you go with input from stakeholders at the beginning. They instead chose, they being DCF and ADS, chose to do it with a waterfall. It's like a concept, basically. This is a concept in software development, in the waterfall method, your RFP has, like, essentially spells out the whole system, right? I mean, if it's not in the RFP, then the successful vendor does not have to do it. There was absolutely nothing in there related to this law about reporting restraint and seclusion to us. We let them know because they reissued this twice, I think, in the last year. They issued one, it was about a year ago, and then they pulled it down. We had a whole bunch of meetings with them. We made this known. We made all kinds of recommendations. They were gracious and met with us. And then essentially what we got was, well, this is just the way we do things. That really was what it boiled down to. It was like there's systems in place. And so there's nothing about restraint and seclusion reporting in that new RFP, which means it's not going to be in the new system, right? And this is frustrating because
We have to pay extra for it to add it.
exactly.
Yes.
Change order.
Correct. And it, you know, I'm sorry, Representative Garfano, I'm not just, the CDDIS, which is the information system for CDD, is over 100% over budget right now, which unfortunately I think is setting the precedent for this US system. And but anyway, okay, that's a whole other topic. So I just wanted to emphasize that. You know, just to go through really quickly. Oh, and I'll say too, actually, that part links up to H30 because the third component, and I'm on page 2 of our handout now, kind of in the middle under H30 components. So it says 4 main components, the bullet point in the middle of the page. And the third one would require that ongoing modifications to the department's IT system include processes for collecting and integrating data pertaining to seclusion and restraint. Fortunately, that ship has now sailed, unless they pull this down or something, right? I don't know. Yeah, so it connects directly into this bill. You know, obviously this bill was, the RFP went out about a month ago. So when this bill was initially conceived, it had not gone out. And so maybe I'll get to just the legislative suggestions here. I mean, there's more on H30. I think H30, I think we all agree that, you know, H30 itself in its current iteration is not ready for prime time, but we have a bunch of suggestions here. And I should say, I want to thank the sponsors and you all. Honestly, we were surprised and thankful that you gave this a hearing. So we really appreciate that. So we have a couple suggestions on the bottom here, Lauren. I'm sure you can add some detail here, but I'll just go through them. One is banning prone restraint in all settings with no exceptions. A lot of other states have done that. We don't have to go into the details, but prone restraint is the most dangerous. You can find plenty of information on it on the internet. It is by far the most dangerous kind of restraint. It is not restricted at all in Vermont right now in any setting. You know, there's some reporting that we would suggest, and this actually, we got an email from a GAL early in the creation of this office, and Chair Wood, it went to you, and it was also forwarded to me. And some of the ideas in the second bullet are from that. Because GALs, attorneys, and others, I mean, you know, they can testify themselves, but our understanding is, you know, they often don't know when their clients are restrained and secluded. And of course, there's privacy considerations, but if you have an ongoing case, right, you know, these are often highly significant details that really matter. and relate to, how a child's acting in general and how things are going. Third bullet, standardized reporting requirements. We talked about some of that earlier. Fourth bullet is mentions a dashboard, which we talked about. The second.
Can I just say, you said standardized reporting requirements, it's not just the requirements, but it's also the format and the method.
Correct, right.
Yeah.
I was trying to get it on one line. Yes, yes, absolutely. There's a lot there. There's a lot there.
Yeah.
And there's certainly models for that, though. We don't have to reinvent the wheel on that.
No, of
Yes.
course, but I just like, yeah, okay, I just. wanted to be
Absolutely.
clear.
Yeah, thank you. No, I appreciate that. This second to bottom bullet point, it says require legislative data on restraint and seclusion incidents at Red Clover, See Act 4 of 2025. This could be something that could be done before the end of the year, since you're looking for suggestions. Act 4 of 2025 was H2. This is the bill that delays, it was signed into law by the governor. This delays raise the age on the juvenile justice side for 2 more years. But in addition, it at our suggestion includes reporting requirements about Red Clover, because we thought we needed to know how much Red Clover was being used, what were the treatment needs, et cetera. Restraint and seclusion was not part of that reporting requirement, but I think, if another bill put it in there, it would fit right in with the other requirements that are already law in Act 4. I think it's 2 reports. And also, this stuff we're already getting this. And so, it probably wouldn't be publicly available in the same form that we're getting it, because we have statutory access to confidential information. But there's not a huge administrative burden on the department. And, again, I want to thank Tyler for working with us and all of DCF for working with us on this issue. And then lastly, and maybe you can talk about this if you want or whatever you want, leverage the expertise of current Vermont providers who employ zero restraint policies, because there are some. And, I think it might make sense to hear from providers what their perspective is on this, because I'm guessing that folks who work with challenging youth would have a different perspective that could be valuable. But certainly the ones that are really have very low restraint and are working with hard kids have a lot of expertise. And sorry, lastly, the youth, right? We can bring their voices in anonymously, but there's a bullet earlier about youth voice, and youth restraints live in the bodies of youth. They tell us about them in detail, months, years later. It's trauma. It really matters. And even when they see their friends restrained, they tell us about that too, right? Thanks.
Yeah, I think one program that comes to mind is Howard Center's Park Street program. They work with adolescent males who have sexually harming behaviors, and they're able to not use restraints. And so really understanding what other clinical practices they're using is a great insight. And there are other programs as well. And then to the point of elevating youth voice, if I could just read one more incident of seclusion that was reported after our annual report was complete. The information provided was the date, the name of the child, the program, yes, seclusion, total 42 minutes. And so it was at a program that serves young children. So I had the name, and then I used my access to look up the child. And it turns out this is a Chins B child. So in the custody under abuse or neglect, he had just turned 12 years old. So he was in a program, maybe under a variance, but that's normal practice as well if the program can serve him. But the case plan read that this child is developmentally delayed and still in pull-ups and not attending school for full days yet. And the program that secluded the child for 42 minutes, I have been in that seclusion room. And honestly, what went through my mind was who was supervising this seclusion, who had eyes on the child. Did the child soil himself in his pull-up during these 42 minutes? How did he get out of the seclusion episode? What was the debrief like? Did we change his plan of care accordingly based on what we learned? So I point that out to say that the data is crucial to get more information, right? And then for us to connect the dots, both individually to enhance plans of care, to work on creating sound de-escalation plans, but then also to create some systemic change, right? And really create some responsive system of care, because we hear from DCF and from children, that's what we need. So it is imperative.
And seclusion too, I mean, this is a rhetorical question that maybe a future witness could answer, but I personally, honestly, truly do not understand the need, even under a safety concern, for a 42-minute seclusion, because the definition of seclusion are essentially the child is not essentially not being touched, but knows they cannot. There's force being exerted, non-physical force being exerted, so that they know they cannot leave this space. Right. And if you are saying you need to create temporary safety or stabilize a child or protect them from, okay, fine, it might protect them from somebody else. I will say that, but protect them from themselves. Right. And if you're talking about a child with those attributes, I would just challenge anybody out there to come in and explain to you all why this child would need to be in there for 42 minutes. Right. So again, I think programs would come in and say, we work with very challenging youth. We have to have tools to be able to get through the day safely. Adults are injured in these sometimes, in restraints sometimes, absolutely. And all of those things are valid. It's just really a question of degree and a question of are we keeping children safe and are we keeping adults safe, right? Because that just shows that those needs are linked, right? And then maybe lastly, I'll just say, I think if I had a quarter for the amount of time I talk to a youth, like even if you read a report and you go in and you say, and the report says, youth refused to comply essentially in some way, right? And did a thing and then lashed out it. And then the restraint occurred. So many, if you sit down with them and you say, what was going on for you that day? Right.
Right.
So often you hear it was the anniversary of my friend's death, or it was my mom's birthday, or it's Christmas time and I was feeling whatever, right? Or this other kid said this thing to me this morning, or whatever, right? Like these are kids and they have bad days, and so often that antecedent part, right, is crucial to what happened, and all you see on paper is essentially child was a pain in the butt, right? And that is, behavior is communication. That is a manifestation of something else that's going on. And yes, that adult cannot always solve that in that moment, and ultimately people have to be safe. But there really are limits on that. And tragedy ultimately happens when systems just continue to sort of overrun the reason why we have. So I appreciate you listening to.
So you've spoken to us with us today with great passion and as advocates. You led by sharing that you operate an office that is independent and nonpartisan. Can you share a little bit? This is a program that's new to be your office. How is it that you're appointed? Do you feel that you operate with independence? Are there any limitations or restraints that concern you?
Oh, thank you. I appreciate the question. The governor nominates the advocate. The Senate confirms the advocate, 4-year term, removable only for cause. So, serious misconduct type of stuff. The advocate hires the deputy advocate. We're both exempt employees. 4-year term, I suppose at the end of 4 years, the governor could nominate somebody else. I'm not clear on that, honestly, but that's, yeah. So in terms of our independence,
Is there an advisory committee that submits a recommendation to the governor?
correct. Sorry, I left that out. Thank you. The Oversight Commission on Children Use. Excuse me, Chair Noyes. I apologize. She's the chair of that commission.
Oh.
That's why
Yeah.
I respect him. So the Oversight Commission submits names of candidates to the governor, who chooses one, and that's so. In terms of independence, yeah, honestly, I would say yes, I think we certainly, no one calls us and tells us what to do. I think the limits are frankly small p political, in the sense of not Democrat, Republican political, but at a certain, we have to work with people. We can't just be out here screaming and shouting about things going wrong. And there was a lot of concern when the office started about us being adversarial. And since unfortunately we've taken all of Tyler's time, but you can ask him if he thinks we're adversarial. I mean, we disagree on things, but I think it makes for a healthier state and a healthier DCF and a healthier everybody. But yeah, I feel like our independence is real. I think one thing that impacts our independence is this is 100% of our employees right here. That's a real challenge because I'm an appointing authority, which is an administrative thing. And even for a small office, there's a certain amount of administrative work that has to be done just to keep the lights on. And that when there's only two of us, that really impacts our ability to visit children and programs, et cetera. One final thing I'll say is we recently were proud to receive, we were selected as one of 8 sites nationwide. We wrote this grant and we led this project. And it's a collaboration with DCF and the prosecuting attorney and a bunch of other folks. And we got $1 million 5-year grant from the feds to do, I can tell you about it, some other time, but essentially to improve, to keep more children out of foster care, improve legal representation, et cetera. You may know what's coming next. A couple of weeks ago, Doge got its hands into that grant and killed the whole thing, all 8 sites. So we lost that. We were going to have a third employee a temporary employee for 4.5 years, which was really going to support our intakes and that project. And so that was a huge blow. Yeah. And so that does impact our independence because, even if all the laws are functioning well, there's really only so much time in the day, and it's kind of over. Our mandate is huge, right? And technically, we work with impacted families in all 6 departments of DCF, right? So that would include child support, it would include economic services, disability determination, right? OEO, and I didn't mention child welfare, juvenile justice, right? So it's a lot. And with 2 people, I like having a big mandate for sure, but it does impact our independence, our ability to really exercise our statute. Thanks for the question.
Our access to children and youth in DCF custody, our access to facilities, and our access to the judiciary information and DCF records directly also supports our independence. So we are able to receive complaints and referrals directly, but then as information comes to us, we can respond accordingly. So that happens more organically. For example, the information coming out about Mount Prospect Academy and Sentinel, that's really important to our office. And I think what's also what I would like to brag about, if I might.
Please. I had bragging years ago.
Here, and Tyler as well. There's something magical, if I can use that adjective, happening. And maybe DCF leadership won't think this, but DCF workers are reaching out to us directly also for help with tough cases. Right. And so that I haven't heard in other ombuds offices across the country. So we're still a new office, but we are building some solid trust between our small office and their very large department, right? And so I that always strikes me every time it happens. I'm just bowled over that they're reaching out to us for help.
I think it goes to the fact that as you opened that it's not partisan, it's not governmental even, it's really about people who are caring about youth and kids who need some support. So that I think that's a nice sign. That's a good sign. Yeah. Thank you both for being here.
Thank you for having us.
Really appreciate it. We'll be having further discussions about this bill. It's obviously something that is not, it requires a lot more testimony, but thank you for helping to sort of tee us up for our work in the coming session.
Absolutely. And please reach out if you need any further resources. I was going to include more information and I sort of settled on a less is more because I didn't want to overwhelm everybody. But we have a lot more information. For example, you can look this up yourself too. The New Hampshire Advocate did a great report about 4 or 5 years ago on restraint in New Hampshire. I would love to do that again to people's heart, but But please reach out as you need anything. Thanks.
Thank you very much.
Thank you.
That was very informative.
Thank you. Oh, and thanks to Tyler for,
I was just gonna thank him myself.
well, I thank him for myself. Thank you, Tyler.
Tyler, thank you for your flexibility and, Lori probably already got you rescheduled, but, we appreciate one, you being here and listening into, the questions and the thoughts and, we will hear from you directly, in the not too distant future.
Thank you so much.
Thank you, Tyler. Okay, we're shifting gears here to H248. And as we heard from Representative Holcomb yesterday, she has an amendment that is posted on our committee's website. We're awaiting Emily Byrne from on her way up. Okay, from Joint Fiscal, because she has very limited time frame, as do Legislative Council. I think she's going to be a little bit quicker, so she's going to go first. So she'll be here shortly. And that reposted today, or do people have to look back to yesterday, Lauren? It is. Thank you. Yes.
I am here. I could speak to, Beth St. James, Office of Legislative Council. I could speak to the pre-K. But Katie, you would need Katie for the DCF piece. So,
She's coming.
right, I'm just saying, if you wanted to get started,
Oh, okay. I'm aware that Emily she's got like 15 minutes.
Okay.
So I would hate to get you like here and then off again. And I know you all only have a certain amount of time as well. But if she doesn't show up in 2 minutes, we will move to that alternate plan. See? Take a seat.
You're gonna make me go first.
Yeah, you were first. You have the more limited.
I think my 11:30 is canceled if you want that.
That is up to you.
I'm good with that.
Okay, it looks
I've been
like,
in the chair for the last hour.
okay, all right. Okay. You were getting due priority because of your schedule, so, all right, welcome Beth, thank you for being here. And I'm gonna do brief introductions because this is your first time in committee this year. We're making a goal to see every person in Ledge Council.
How are you doing on that?
We're doing pretty good. So Teresa Wood from Waterbury, also serving Bolton, Buell Score, and Huntington.
Regular on Essex and Essex Junction.
Julie Micco from Bridgeport and also represent Middlebury, New Haven, and Weybridge.
That's pretty cool.
Good morning, Todd Nielsen, represent Brandon Forestdale.
Ben Bishop, Colchester, Chittenden 20 District.
Hi, good morning, Eric McGuire, representing Rutland City.
Good morning, Dan. Representative Hyde Park, Johnson, and Belvedere.
Excellent. Nice to meet you all. I'm Beth St. James, Office of Legislative Council. I am your education policy attorney. How do you want to proceed? Do you like sharing screens in this room?
Actually, there's a lot of people interested in
Okay.
this, so I think that would probably be a good idea. And we have not, Representative Holcomb only gave us the background information about why she's interested in this amendment. So we've not looked at any language.
Okay. Let's see. We just sign into, do I have a Zoom?
I think I'm sending an invite, but I'll send it to you. I'll email it to you this week.
Oh, it is. There it is in location. Thank you. And because universal pre-kindergarten is duly regulated by the Agency of Education and the Department of Children and Families Services, Katie and I tackle it together as far as Ledge Council is concerned. And it's this amendment in particular is kind of a nice split because there's a pre-K piece of it, and then there's a CCFAP child welfare piece of things. So we've split the duties pretty evenly. I can absolutely speak generally to what Katie's sections are doing. But if you have specific questions, she's gonna be your gal. How's that? Perfect. Okay. So this amendment starts with, and for the purposes of this conversation, I think you can relatively ignore the highlighting. That was really to show the difference between what you all voted out of committee and what the amendment is doing, more for editing than anything else. So the first section of the amendment is amending section 829 in Title 16, which is our pre-kindergarten statute. This is when you hear talk about Act 166 or universal pre-kindergarten, this is the law that we're talking about. And currently, how much of you all talked about universal pre-K this year?
Not much.
Okay, so universal pre-kindergarten education, as far as the publicly funded piece of it, is the way it works, just as a little bit of a primer, is for kiddos that are 3 or 4 years of age or who are 5, but they're not yet enrolled in kindergarten. Every child who is in that age range is eligible for up to 10 hours of publicly funded pre-kindergarten education. Where that pre-kindergarten education takes place is really up to the family. It's the family's choice. If their school district provides pre-kindergarten education, they could enroll in the program provided by their school district. And it is up to school districts whether or not to provide pre-kindergarten education. And then another layer of discretion is, what does that pre-K program look like? Some school districts have robust full-day programs. Some school districts only offer the 10 hours that are publicly funded through UPK. You do not have, the way the law works is you do not have to enroll your child in your school district's public pre-kindergarten education program. You actually have a choice of enrolling your child for up to those 10 hours a week for the school year, so 35 weeks, in a private pre-qualified provider. All parent choice.
Who qualifies the provider?
Excellent question. So pre-qualified providers are, let's see, I think we have the whole statute. So I'm going to skip down to subsection C, which is the pre-qualified piece. So pursuant to rules jointly developed and overseen by AOE and Human Services, the agencies jointly determine whether the education program, the pre-K program, qualifies for as a pre-qualified provider. So it is truly jointly regulated. The rules that are referred to in the statute in section 829, I believe the law contemplates joint jurisdiction of that, but the State Board of Education holds those rules. And so when they go in to amend those rules, because it's a duly regulated program, they should be collaborating with the Agency of Human Services.
A question, Representative McGuire?
I'm just, reading my mail.
Oh, okay.
So the 10 hours, you can enroll for less than 10 hours. It would be prorated, I suppose, but the way this works is if you are a public school providing pre-K and you decide how many hours a week you're going to provide, the child would just enroll in that program. And because it's a public school program, no money is coming out of the parents' pockets, regardless of whether it's a 10-hour or a 40-hour program for public schools. For private pre-qualified providers, the state is funding coming out of the Ed Fund, and we'll talk about how that works, only 10 hours, and then the parents would pay for whatever is not covered. And it's 10 hours for 35 hours or 35 weeks. So for the school year, essentially.
Go ahead, Representative Houston.
So sorry. So can we go back to the public school, the 10 hours, then it's no, parents don't pay beyond the 10 hours, but somebody does. So the 10 hours is paid for by the whatever the acronym is, and then the remainder is paid by taxpayers.
It's all paid by taxpayers.
Oh.
So universal pre-kindergarten education is kind of that Act 166 is the genesis of this law and this program. And so we refer to it as the universal pre-kindergarten program because there's nothing stopping private providers out there from offering their own pre-kindergarten education that does not qualify for this state-funded benefit. Where the money is coming from for Section 829, the Universal Pre-K program, is out of the Ed Fund. So it's built into school district budgets.
I see.
So I just want to make sure that I'm understanding this correctly. So we know through our committee's work previously with Act 76 and all the testimony we heard there that there's wide disparity across the state in pre-K provision. And I hadn't really thought about it in the way that our previous witness described it, didn't really describe it as a public good, but as a public benefit. So looked at it's a benefit program, if you will, as opposed to public education, is how our previous witness described it. And so what I'm hearing is that if a school district makes a decision to offer more than the 10 hours of the public, I'll just use that person's words for right now, more than the 10 hours of public benefit, and they offer, a full day, full week pre-K, all the state's property taxpayers and sales taxpayers and all of that pay for that.
Correct.
If in private pre-K, they will get some method of payment that's described later from the Ed Fund, but it's only for that 10 hours. And then families pay or CCFAP benefit pays for the remainder part of that. Okay.
But that 10 hours, regardless of whether it's going to a public program or a private program, is built into a school district's budget and is used to calculate your property taxes.
Yes.
And those students are counted in the average weighted daily membership.
Yes, and we'll get there because there is a change here.
Okay. Go ahead, Representative Cole.
And to continue on that point too, about the public benefit versus, public good question. So I think that distinction comes from whether or not the place has to provide a spot, right? So it's a public benefit because not, private places do not have to provide a spot, whereas
Publics don't either.
okay, yeah, that's what I just wanted. That's exactly the clarification I just wanted to get to. So
Yeah, it's not required by school districts. That's part of the issue we were
yeah.
trying to address in Act 76 with the implementation pre-K implementation. So that was part of, sort of our unwrapping the onion skin when we did Act 76 is that there was so much disparity across the state that it really wasn't equal or universal access for all children in that age range. And so whether or not this actually enhances or actually detracts from that is a good question. Yeah,
So I need to ask another question. So you just said that schools don't have to provide this.
they do not right now.
So if a school does provide it, they have to provide 10 hours. That's they have to do.
I don't know the answer to that question. If they do provide it, does it have to be 10 hours?
And at 10 or more.
The benefit to the families from the way that this statute is written is about a flow of money and then the regulation.
It's about money. It's not about what's provided.
There's nothing in Section 829, our pre-kindergarten education statute, that requires a school district to provide pre-kindergarten education or to provide a certain amount if they choose to do so. It's just that the 10 hours is tied to the funding.
So, sorry, but so then it sounds to me that the program is, when you talk about it being a flow of funding, it's about equalizing how we're going to pay for any of this education across that's the notion of equality that's involved, not the equal education of our students. That's not a question here. Our students aren't part
It's
of
not
that.
even about equal, it's not even about equal.
It doesn't come out equal. It doesn't come out equal,
No.
but it's an attempt at something like
School
that.
districts receive more in resources than what is paid to private providers for the same service.
I see, yeah.
So I mean, I think that was actually, to be honest, a little bit of an illumination in thinking about it in terms of public benefit versus public good. And in Act 76, we really were assigning a responsibility to school districts. So this was part of the charge of the implementation, pre-K implementation committee, assigning responsibility to school districts for providing or arranging for the provision so that there would be an entity responsible.
Okay.
So that meant, our intention was that we would actually have universal access to pre-K through the public school system or through their contracts with private providers. So it was still maintaining a mixed delivery system, but it was equalizing access. So it was saying, in some of our more rural communities, as a school, you might not have, as we heard from somebody yesterday, you might not have space for pre-K in your building. But if you don't, then you have to figure out how you're going to do that. So that the kids, if you're a school district,
Yes.
If we had the work done by the pre-K implementation committee that we were hoping to have done, it would have said, school districts, you have to figure out how that access is going to happen. So this is the way I understand this amendment. It doesn't do anything to equalize access at all.
Just where it's
It's
getting
about-
paid from.
Where it's getting paid from.
Yeah, I think I understood that yesterday.
Okay.
Absolutely. Thank you for teeing me up. So that's pre-K, that's how it works. And what this amendment does is exactly what your chair just said. It does not change eligibility requirements or the amount of funding. It changes the source of funding. So this section 1 amends section 829 in Title 16, the pre-K education statute. And current law is all about public and private. What this amendment does is it says, if you are a pre-qualified public provider, which means a school district that provides pre-kindergarten education and is qualified pursuant to subsection C of this section, then you have to follow all of the universal pre-K rules that aren't changing. And the money comes from your school district budget.
Now, this answers his question about it. It even says no fewer. So it had to be at least 10 hours. It couldn't be fewer.
So if a school district is electing to operate a public pre-K program, they still get to pick how many hours they're offering. They still get to pick whether, their how many slots they have available. But if it's a public school district offering the program, then the money's coming out of the ed fund, just like it is now, exactly the same. What this amendment does is it takes out all the references to private pre-qualified providers. And we're gonna put them in somewhere else. So if we look at on page 2, line 6, again, as you all know, if the language is not underlined or struck through, it's current law. If it's underlined, it is the proposed amendment, and the strike through is current law that we're proposing to take out. So on line 6 here, subdivision 2A, if a parent or guardian chooses to enroll a pre-K child in an available, pre-qualified, or inserting the word public there, then pursuant to the parent or guardian's choice, the school district of residence shall pay tuition upon the request of the parent or guardian to a public school located outside the district that operates a pre-K program, or enroll the child in that district's pre-K program. We're removing the option to pay tuition, a school district to pay tuition to a pre-qualified private provider. And we're building a new source of funding and a new process here. So on line 17, if a parent or guardian chooses to enroll a pre-K child in an available pre-qualified private program, then pursuant to the parent or guardian's choice, BCF pays the tuition. And then there's a whole, as we continue to walk through, there's a whole new piece of law added regarding the enrollment process for private providers.
Go ahead, Representative Bishop.
Am I understanding this current statutory language correctly? That if I live in Underhill, but I work in Burlington, and I have a preference for having my child close to me during the day, I might be able to see them, whatever other reasons. I would have to pay for them if I can't enroll them in the public school program for pre-K in Burlington without paying, which I don't even know if they would allow.
No, so you could, that would be a district policy. So all of our school districts have their own out of district student policies.
Okay.
So they have policies on how many students from out of their school district catchment area could enroll in various different programs. So it's possible that Burlington accepts Burlington pre-K programs, depending on the school or what the program is, does have a provision for out of district residents to enroll. That's
Okay.
going to vary on a school district by school district basis. Yep.
And if they did, and if the child was accepted into that program, then they will get this payment for 10 hours
From their district of residence.
from the district of residence to the districts of attendance where you attend.
And if it costs more than that, then the Burlington School District is paying for that. But the
Really?
reality is we're all paying for it.
Yeah, we're all paying for
Yes.
it. Yeah. Just some exchange of money somewhere.
It's in their budget.
Yeah.
Yep.
So the budgets come out even. That's great.
Yeah, go ahead.
That brings up another question. So Winooski decided, okay, we're gonna do 40 hours, but everybody in Vermont pays for it. How is that allowed?
That is how our public education system works currently.
Wow, doesn't seem quite fair. Okay.
School
That's
districts.
what we
For the
felt.
kids, but
That's what we felt in Act 76. Felt that it wasn't fair. You know, it was like, you said,
Yeah.
good for those kids there, but not good for some kids in the Northeast Kingdom or Southern Vermont that don't have access to anything.
Well, and schools that don't have the space, they happen to have that whole new facility. Other schools are struggling with a lottery to even provide it to a few kids.
Right. Which same would, you could say is true for any opportunity schools provide, whether it's pre-K or extracurriculars or whatever that's built into their school budget.
Yeah.
All Vermonters ultimately pay.
Yeah. Wow,
Correct. Although
that's crazy.
you all voted out H 454, which makes some significant changes to our education funding system. So let's bookmark this conversation.
Yes.
Oh, good idea.
Let's see where we are next year. Okay, so section 1, we're keeping the entitlement the same. We're keeping the regulation of the programs the same, duly regulated. But the funding source for public schools remains the same. The ed fund, school districts budget, they're paying, public school districts are paying tuition to other public school districts if a child is going out of district, and it's still parent choice.
So one might ask, why would it be duly regulated if they're each paying for their own?
That is a policy choice.
Yeah. Okay, that wasn't clear to me before, so thank you for pointing that out.
Okay, so if a parent or guardian wants to enroll in a private program, then we're going to scroll all the way down. So there's lots of conforming amendments all throughout this statute that does exactly what I just described. Takes out the pre-K private providers, and we're just looking at public providers coming from the ed fund. But the regulation of pre-K providers that are eligible for any sort of public funding is still in this statute. And we're gonna skip to, again, you can ignore the different colors.
Okay.
There is a clean version of this. I didn't realize you didn't have it. The rules remain the same. We require, so this is in the rules. Just building in some differences now that we've got two separate places for private and public. Some of the rules may have to be amended. Current law allows for a school district to limit geographically where they're paying tuition, and this section is repealed.
Okay.
And then we're going, so I'm on page 12, line 6, a child receiving pre-K education in a pre-qualified private provider shall not receive both tuition for a publicly funded pre-K program pursuant to this section and a CCFAP subsidy. I think is Katie here?
Yeah.
Okay. I think we need to look at this.
Well, because that doesn't make sense
Yes.
to me, because
Yeah.
if it's only 10 hours, then the other hours, they would be eligible for a CCFAP subsidy.
My understanding is, I'm guessing that this language is going to go away. Because my understanding is that what the rest of the amendment does is say, for private providers, you can get that 10 hours, but it comes out of CCFAP, whatever funding source is for CCFAP.
Mhm.
And you can also receive whatever you're eligible for under the current CCFAP rules and regulations. So it's two benefits, same funding source.
But different periods of time, I guess,
Yeah, absolutely.
theoretically, it's, maybe a unnecessary distinction in the
Yes.
end if this were to pass. Like, why would we distinguish 10 hours from another 30 hours?
I think this is a policy choice for you, but right now there's no income eligibility requirements for the UPK 10-hour benefit.
True,
Yeah.
yeah.
So,
Which is
Just
good.
come from CCFAP.
yes.
But I guess I would ask,
Yeah.
would this language be changing in light of what starts on line 9 through 12 or a siblings participation? Because then it seems to, maybe it says
I
what it
think-
intends to say.
I think Katie and I need to talk about this with the sponsor.
Yeah. I don't know, that happens very frequently. I mean, just, Nolan will show up when his name is mentioned, and it's like, it's strange and peculiar. But this doesn't make sense to me.
It doesn't make sense to me either, and I need to connect with Katie on that.
Okay.
So we're gonna move on to section 2. So average daily membership is the way we count students for our tax calculations for property taxes. Right now, the full-time equivalent enrollment for each pre-kindergarten child, school districts count their pre-K, whoever they're paying those 10 hours for, whether they're going to the public school or they're going to a public school outside of the district, or they're going to a private provider located anywhere in the state. If the school district is paying for those 10 hours, they get to count one student for each of those pre-K kids they're paying for. What this amendment says is now school districts are only counting who they're paying the public tuition to public schools for. So if it's their own school district or they're paying tuition to a public school located outside of the district, they count that pre-K student as one.
A question, if they're counted in the ADM and the school district is offering simply a 10-hour-a-week program, but they're getting the benefit, are they getting the benefit of a 0.25 student, or are they getting a full student?
So right here, if a child, so on line 2, on page 13, if a
Okay,
child is
sorry.
enrolled in 10 or more hours, then they count as one full-time equivalent.
No more.
And then starting on line 5, we start to prorate. If a child was enrolled in 6 or more, but less than 10, then it's prorated. And you don't count them at all, if they're enrolled in less than 6 hours per week.
So I don't understand the less than, and this is existing law, but I don't understand the less than, because just previous to that, it said it could be no fewer than 10 hours.
I think this is about enrollment. And so I think it's possible that the benefit that's provided can't be less than 10 hours, but a child's family may only elect to send them there for 4 hours a week.
Okay.
So again, just so I can make sure I'm clear on this. So a school district can get credit, receive money for one whole student, even if the child comes for just 10 hours a week.
Correct.
If it's a private center that's receiving money related to the UPK student, they're receiving simply 10 hours.
No, the school, this is
Well,
about,
not under currents.
this is about how we calculate property taxes, not how much
Money.
money a school district is receiving to run the pre-K program. This is when we're counting pre-K through grade 12 students for our property tax calculation. We have to count how many students we have. It's based on a long-term weighted average daily membership. And you start with, for pre-K, you start with figuring out, is the child enrolled in 10 or more hours of pre-K? And then you're counting those students for the purposes of the money that's going to that school district to pay for every service they provide.
Right.
How the school district allocates those funds
Right.
is up to the school district. So this is this to me, this does not say that a public school district gets money to run a pre-K program. It's how many students they're counting towards their overall education payment, the calculation of their overall education payment. And then they have to figure out how to make that work with everything else they have to pay with.
So I'm just going to encourage questions to be thinking about how not necessarily how we're calculating property taxes for public education, but who's paying for pre-K in what setting. Okay, just because we have two more witnesses and we only have till noon, and all of that is very interesting, helpful, and informative. But it is all potentially going to change. So,
Yes.
Yeah, go ahead.
Just quickly, if I can make a statement. Yeah, I appreciate what you just said, because that's where some of my concern is at this time. I am trying to decipher how this all amendment relates to the bill as we passed out, and in regards to how it relates to human services endeavors altogether. I feel that this should be, I have a multitude of concerns with this amendment. 21-page amendment that frankly, I believe should be down in education. And it is really getting difficult to.
It will go there after here.
I understand that, but I am
It's been
a
my
multitude of
The
concerns.
launch part of the education reform.
Yeah.
Yeah.
So I just felt it was
Appreciate it.
appropriate to make that statement. Thank you.
Thank you. Okay.
Are we good with this section?
Yes.
Okay. Then I'm going to turn it over to Katie.
Good timing.
We are on page 14. The Child Care Financial Assistance Program, supplemental childcare.
So this is your original language from your bill H 248, so there's no changes here. And supplemental grants. There are no changes in Child Care Financial Assistance Program, section 4, to your language. The wrong version of the language. It still has language that I struck.
I know, I didn't. No.
This is what we were given by the sponsor of the amendment.
Okay, we will have to strike this section 7. And then section 5, payment to providers. This is also the language from your underlying bill. It was done as a.
Okay, so let me just double check. So paragraph 7 here is not part of the amendment. Okay.
This is the exact same language that I noted that appears earlier?
It appears 3 times in the bill.
Yes.
Okay,
And an earlier version of the amendment. And
Okay.
it has been removed.
Okay.
So this version still retains it.
okay, so if someone could get us what the official version of the amendment is, so we can post that and take this one down, that would be great.
Sure.
Thank you.
So 5 is your language from your bill. And then section 6 is new language specific to the amendment. This creates a new subchapter in the childcare chapter in Title 33. And this is pre-qualified private pre-K education. This is sort of a companion piece to what's in Title 16 to talk about how pre-K would be administered on the ICDD. So a parent or guardian may choose to enroll a pre-K child in a publicly funded pre-K education program operated by an available pre-qualified private provider of the parent or guardian's choice pursuant to 829, that's the language Beth has already walked through with you, by providing written notice to the Department for Children and Families on a form created by the department for this purpose. And the child is or will be admitted to the pre-K education program operated by a pre-qualified private provider. Upon receiving written notice, the department shall pay tuition to the pre-qualified private provider for not more than 10 hours per week of publicly funded pre-K education for 35 weeks annually from the state portion of funding appropriated for CCFAP. So let me just pause there. As you know, CCFAP is a large portion of it is federal money. The state also invested a large portion of state money. The federal money has a lot of constraints around how the funds can be used. State, you control the parameters around how that money is used. So that is why this specifies that it is the state portion of CCFAP funds. In subdivision 2, the department.
I'm sorry, can I ask, and state portion, is that a general reference that it could be general fund or tax revenues? It doesn't matter?
Funds, what is currently the CCFAP appropriation that is not coming from the federal government. So what you are currently appropriating for CCFAP that is not coming from the block grant.
Okay.
In subdivision 2, the department shall pay tuition on a schedule that does not inhibit the ability of a parent or guardian to enroll in a pre-K child in a private pre-kindergarten education program, or the ability of a pre-qualified private provider to maintain financial stability. In subdivision 3, prior to making an initial tuition payment, the department shall enter into an agreement with the pre-qualified private provider to which it will pay tuition on behalf of a child regarding quality assurance in compliance with 829, which we've looked at, and any other matters. The agreement is to require a pre-qualified private provider to notify the department if a pre-K child for which it was previously receiving this tuition payment and is no longer enrolled in the program. So that's language that mirrors what's in 829 with regard to private or to public programs.
And so, and this gives, this has the Department for Children and Families determining a tuition payment, an amount of a tuition payment that will be paid for these 10 hours.
Where are you getting at?
Well, the department shall pay tuition on a schedule. It's, you just went over it. Line 14 on just the previous page. The department shall pay tuition on a schedule that does not inhibit the ability. So that's making assumption the department is determining a payment level.
I had used schedule in the meaning of calendaring, like at a time that would not prohibit the
So who determines the tuition, who determines the amount of the tuition payment?
I imagine it would be in line with what's happening in the public program, but we don't have language that specifically says that.
Okay. It's not currently comparable.
The pre-K payment to the two programs.
It's currently calculated differently. Okay. So it doesn't address that.
It does not.
Okay, so I was misinterpreting that line.
In subsection C, pre-qualified private provider may receive additional payment directly from the parent or guardian only for pre-K education in excess of the hours paid for by the department pursuant to this section, or for childcare services, or both. In subsection D, a child receiving pre-K education at a qualified private provider shall not receive both tuition from the publicly, this is the language is being filed.
Right, so can I go back to section C? I think this is referencing part of the discussion we were just having with Beth a couple of minutes ago. So in the public school system, the education fund pays for, regardless of whether it's 10 hours, 20 hours, or 30 hours a week of pre-K. And here we're saying that it is responsibility of the parent or guardian in excess of 10. Is that correct? That seems rather inequitable to me, but okay, thank you.
And then I'm just cross-referencing in subsection E definitions that are used in 829.
Okay. And then amending the name of that. Okay, so we've been asking a lot of questions as this has been moving along. So let's concentrate now on any questions that we would have for Katie about the role of DCF and the role of the Child Care Financial Assistance Program. Those are all within our committee's jurisdiction. So wanting to make sure that essentially what this is doing is saying now 10 hours of pre-K for families who elect private pre-K would now come out of state funds because we can't use federal funds for that purpose. And so that's what this is saying. And it is also saying, as we just commented on, that anything above 10 hours, the family would be responsible for in pre-K, which again is inconsistent with what is available currently in education, in public education setting. Anybody have questions for Katie on this? Okay, go ahead, Representative and then Representative McGuire.
Thank you. I just want to underscore then the question of how tuition payments rates are determined and whose responsibility is that for this 10 hours? And is that the same?
It's an unanswered question.
Yeah, it's an answer, so it probably needs an answer. Yeah.
We have Representative McGuire and then Representative Steady and then Representative Donahue.
I'm good. I was on touch on it. Thank you.
Okay, Representative Steady.
So my concern is, so you're saying like Milton, that's where I live, they do not have enough space. So a parent that doesn't win the lottery has to pay now for 10 hours, where before if they could get into a private setting, the school still paid it up to 10 hours.
What this amendment does is it sort of keeps the structure of a pre-K, of the current pre-K program that offers 10 hours a week in different settings, and it's sort of splitting how it's funded. So right now, the funding is all consolidated and it all goes through the school district, even if somebody is sending their child to a private provider.
Right.
So what this does is instead, if a family is choosing a private pre-K provider, then CDD will manage that flow of money and that benefit, and it would come out of funds that are appropriated for the Child Care Financial Assistance Program subsidy.
Okay, so the school still will pay it if they don't have space and they have to go to a private.
No.
But the state,
It'll be paid, it'll just be. No, but the parents are paying twice because they're paying their property taxes. I mean, what, how screwed up is that? They're paying their property taxes in Milton. They can't get their child in, so they have to do the private. And so then it goes from the state where they're paying their property taxes again. It's like screwed up. But I'm a big property tax people paying. That's horrible. Okay. It's kind of sad.
Well,
I was just gonna say, the state is still paying. So, in the ed fund, we pay via our property tax.
or partially.
Or partially, property tax, sales tax, a bunch of other things. For CCFAP, the state funds are derived from two sources. Okay, one being the general fund, which is all the general taxes that we all pay. And the second being from a specific, it's called the child care contribution, which is a payroll tax. So the state is still paying for the 10 hours. But anything, the comment that I was making was anything above the 10 hours for private pre-K in the pre-K program, this amendment says that the family's responsible for. If you get more than 10 hours in the public system, the family doesn't have to pay an extra amount. It's
No equity. Okay, I got it, still not fair.
So we have
I
Representative
knew
Donahue
it,
next.
equality and equity and inclusion.
This is already helped a little, but I am often more of a kind of pictorial, and maybe somebody on the committee who understands it can do this, or maybe it's Katie, but it would really help me to see a flow chart of the money.
Yeah.
Current versus proposed. Where's it coming from and where is it going to in terms of?
I mean, I can do it right now over there. It's really.
Oh, yeah, you can't erase that.
Really enjoy that.
Oh.
I'm just saying, it is.
I mean, but so maybe you could just scratch it on a piece of paper quickly and.
Sure.
Or whatever, because that flow is what I keep getting confused.
It just doesn't seem.
What money is paying for which segments of that? Because we've got the 10 hour in private, the more than 10 in private, the 10 in public, the more than 10 hours in public. And where the money comes from, and then where it would come from in the amendment.
I'm happy to do that. I'm cognizant of your time.
Yeah.
On the spot.
Okay.
We need it right on the spot. No.
Yeah, and it's also something perhaps we can reach out to, JFO is here. And maybe they can respond to that. So I'm gonna wrap this up with these three questions. We've got Representative Bishop.
Mine's more
Representative-
discussion.
Okay, Representative
rather than
Bishop, and then
question of
Representative
Ledge
Cole,
Council.
and then we're gonna move to JFO, who is going to wrap this up for us this morning.
So two things, I'll try to make them quick. The question of inequity about parents needing to pay past 10 hours in a private setting versus perhaps not in a public setting if they offer a program more than 10 hours. That inequity exists today and would continue in this, and not change necessarily, but okay. But also want to just confirm, bless you. There's no changes to the ability to both use UPK and qualify for CCFAP.
No, so that's the language that was removed from this draft that was in there erroneously. So the amendment, the correct version of the amendment would allow a family to use both UPK and CCFAP if they're income eligible for CCFAP.
So the bottom line.
Not for the same number of hours, though. They don't get paid twice for the 10 hours.
Right.
I'm just being clear about
Sure.
that. for everybody.
Very good.
So is it accurate to say that the bottom line from a family's perspective is what is subsidized in whatever form does not change as a result of this?
Correct. Right now, a family who's in a private provider could receive a UPK benefit. And if they're income eligible, they could also receive a CCFAP subsidy for the remaining hours of their care.
Representative Cole, and I think Representative East just had his hand up too.
I
You
think
okay?
mine is more
Okay.
discussion. centered.
More discussion,
Yeah.
okay.
I need to.
So the only people who would really affect is people in Winooski. Like he said, if you wanted to bring the child closer to your work or something, and they get full-time there, they would
All of that
have,
would stay the same,
they would still get full-time in a private.
wherever they
All those
are.
inequities.
So they would still get like time in a private setting.
It doesn't really, I mean, I think the bottom line,
And
this
another-
doesn't do anything to erase or improve upon inequities in the system.
Okay.
Structural inequities.
And property.
They remain.
That's all education coming out of people's pay.
Right, that's just the bottom line, just to summarize. Thank you both for being here on such a busy time. And we're now going to turn to JFO for some background about what JFO is going to be doing in the off session about this whole pre-K question. Because as you may recall, in the bill that the House passed out, there was a section in there about really needing a significant more information about pre-K than exists currently. And so whether or not that piece, whether or not that language remains in some version of education reform that may or may not get passed this year, who knows? I think we have Emily here because this is going to be a topic of ongoing conversation and decision-making needing to be made about it. So thank you, Emily, for being here.
Yeah, thank you for having me. So Emily, for the record, Emily Byrne from the Joint Fiscal Office. So I think in a nutshell, right, so the education transformation bill that passed the House included a requirement for the Joint Fiscal Office to do a study on pre-K, preschool. JFO has received a lot of questions as part of the conversation around education transformation, as sort of how does pre-K fit into the whole, the larger context of education, public education financing and funding. So I think JFO's plan is to, if that language passes, and possibly even if that language doesn't pass, is to look into this because there are multiple funding streams. The federal government is involved, state government is involved. We have a new program that's ramping up while sort of changing the public sector side of this thing and sort of how is all the money, like to try to document, right? Like the flow chart you asked for, that would probably be like, page 3 of the report I plan on writing this summer. So we can, get to work on that. But I think that's the flow chart. And I think you have, keeping in mind the sort of 3 entities involved, right? You have the parents, the providers, and then the sort of state/school district. And depending on what income group you fall in, depending on how many hours you're getting, depending on sort of lots of things, whether or not you're in CCFAP or not, and how UPK interacts, impacts the flow of the dollars and who's getting dollars and why and when and sort of all those things. So that I keep thinking of a spider web or like whatever. Once you pull, it's all interconnected, and to untangle it, I think is going to be, I don't know if it needs to be untangled, right? I shouldn't even say that necessarily. Like you got to understand sort of how all of this flows, each of those entities, how they differ, what the impacts are. As we figure out how it fits into the larger public education transformation and the work that was done as part of Act 76.
I particularly appreciate it because, as I mentioned earlier, the Act 76 required a pre-K implementation report. They spent many months in this process and really did not come back with answers to the questions that we had asked them for. And part of what JFO is undertaking is will help us really make some decisions moving forward as well. So kind of the stuff that we had asked for in some of the stuff that we had asked for in the pre-K implementation report. So I don't want to, I guess I do want to underscore that it's a complicated topic. It's going to require a lot of work, and I just am appreciative of the fact that JFO is willing to undertake this. People have any questions for Emily? Okay, so just so people know where we are on next steps, we are going to be hearing from Deputy Commissioner McLaughlin this afternoon. Yes, this afternoon. And we're also going to be hearing from Representative Maricki. And then we will have discussion on the amendment and have a vote probably later this afternoon.
On this?
On this, yes. Okay, thank you all. And Laura, we're done. Have a nice lunch.